And then you left the legislature.
Yes. I was president of the Atlanta Bar Association in 1965 or 6. And we were a smaller town then, not big. The Bar Association wasn't huge in those days. And we sort of had a custom that the Bar Association would, where there was a vacancy, would try to seek out someone who would run. It was not a really highly political operation, certainly not Republican or Democrat. It was a non-political office, really. And I was very moved when I was asked if I would consider taking the post, being vacated by Judge Verlin Moore. Judge Verlin S. Moore was now 90 years old, wonderful man, but he was not going to re-offer for election. And so I was flattered, you know, and I had now several years in the legislature, and that was a tough grind to do that plus practicing law. And I suppose I'll have to say I had dreamed someday of being in my father's position. And I was fairly young. I think I was 47 at that time. I consider that young now. So I ran. I had opposition, but won in a substantial vote. And then Judge Moore retired early, and I took his place, appointed by Carl Sanders, to take my first term on the court.
Mm-hmm. Well, tell us about your career as a judge. What makes a good judge?
Well, I'm not sure. That's always a very important question, and it's one that anybody who wants to go on the bench must consider carefully, else his life will not be a happy life. And many judges are not happy in their careers. I think what makes a good judge, in a sense, in his judicial work, is to be able to take two dissonant positions and in some way or another deal with those without emotionally destroying oneself, and without trying to split the difference. That's not justice in some cases. That's unjust, I think. So to be able to hold two discordant views, consider them, do the best you can considering the statutes, you know, and so forth. Now the trial judge has a challenge that appellate judges don't have much. Appellate judges pretty much can look at the statutes and look at the rule and contrast it to the ruling of the lower court and decide that. The trial judge spends more time than not determining questions of character, questions of judgment. Do I probate this person? Do I revoke his probation? Do I believe this witness? Do I accept the other witness's position, however weak it might be, because that's the just result? There are so many differences between the life and work of a trial judge and the appellate judge that you could write books about it. Because in the long reach of things, the daily work of the trial judge is to do right. He's got to use discretion, which means there's got to be some basis for it. It can't just be flipping a coin. There's got to be a basis for it. And that basis can reach into, if you could, the very heart of a person. And then that's what great judges do, I think. Judge Verlin Moore, whom I succeeded, was that kind of man. Rarely reversed by the appellate courts, but a lot of good humor, a lot of sense of humanity about what he did. I think that's what makes a good judge.
Do you think that judges should be subjected to the political process? You mentioned you were elected. Is that good?
In a perfect world, I don't think it is. In a perfect world, judges ought to be selected by those who know them best, who know of their use of discretion, to know of their academic success and their integrity and their intellect. That's the perfect world. I have to say, I don't believe in the notion of just picking somebody out of the crowd and telling him he's the judge. And that's what happens more and more today, because people don't know judges anymore. Back when my father was on the bench, and when I came on the bench, I think most people would know at least the names of the judges. They would know who they are. Now you don't have that privilege much anymore. So you can't make a judgment based on more than maybe celebrity, or maybe just the name. We see an example every now and then of people elected just because their name is the first on the ballot. That's not the kind of judge I would like to have. So I do think in the perfect world, but on the other hand, it's not a perfect world, so we've got to do the best we can to try to identify the best person and then support them. I mean support them, give them money, help them run a campaign, get out there and hustle for them, be a party to it. Right now, most people are disengaged from politics. They don't take responsibility for that. They can raise hell, but they don't do much about going out helping candidates.
Right.
And that's a loss for us in this society, I think.
Let's talk for a minute about the Georgia judicial system. Are we keeping up with the times?
No, I don't think we are. This is a harsh judgment on my part, and forgive me for that, but I'm not keeping up as well as I should with the judicial system. But I love the judiciary, and I love the judicial system. I think it's slow, it's tough, it's not easy to keep up with the times. For example, just to give you an example, in criminal affairs, this is in an immediate working day of a court. In criminal affairs in urban areas, for example, people are bussed into the courthouse by the school bus loads, lined up, come up, wait all day, enter a plea, pile back in the buses, back to the jails. That should be done somewhere in the court, in the jailhouse, and we can do it with television, and we don't have to bring people back and forth. And the indignity of all that, first of all, the danger of all that, secondly of all, the inefficiency of that could be resolved largely by the use of telecommunications, you see. Now in sentencing, that's a little different, I think, because we don't do a good job in this state and in most states in determining who's going to be sentenced and what their story is. In the federal courts, you have a pretty rigid requirement that you have a pre-sentence report for everybody. A probation department looks at it. You get a pre-sentence report. In most state courts around the country, the judge doesn't get the benefit of that at all. The judge just gets the benefit of the solicitor's recommendation and maybe the public defender's plea, but very little information about the psychological component of the defendant or the economic situation of the defendant. And so the judge is given very few options about what to do. And that's not right. In my view, there's more injustice in the name of due process than there is justice. We keep people sitting in jails for weeks and months, never having a chance to see a lawyer or coming. That shouldn't happen. It's not a perfect world, and we'd have to do the best we can, but at least we ought to recognize that people who are arrested are, we believe, presumed at least to be innocent. So yes, I think in the criminal justice system there's a lot that can be done. Unfortunately, it's expensive, but there's a lot that can be done. In the civil cases, we have come a long way since I was first on the bench in the area of resolving civil disputes. We might want to talk about that later, but I've spent some years now in the field of arbitration and mediation.
I do want to talk about that. But before you do, do you recall any major trials over which you presided? Would you share some of those with us?
Yes. It's hard to bring back particular ones, but we always try cases that, I'll remember two that just quickly. One was in the development of the MARTA system in Georgia, where the MARTA trains were going up and down, the tunnels were being built up and down Peachtree. I remember there was a family who owned a little store just outside across the street from the Carnegie Library downtown, and they'd been I think a second generation store. I don't remember whether they were selling hats or books or what, but it was their business. MARTA wanted to condemn the property along that way, and they did, which would in effect destroy their property and take it. And I remember that the case went to trial, and I tried it. It was to be about a 6-week trial, and you always hope to avoid those kind of long cases, but this was a complicated case of value of land and so forth. And that was a trial that illustrated what I thought, in a very acute way, the immensity of the power of government over the individual. They were happy. They had their land, they had their store, they had their livelihood, they have their second, third generation, and yet all of a sudden, out of nowhere comes the government with this huge train coming down the track to take over their land. Well, it was a good trial, and everybody did a good job and tried the best they could, and it did come out, I think, as best it could. They the jury gave a decent value to the land, and these people were paid for that. Mm-hmm. I thought that was a good way to get rid of a case where the public had to be served. We had to have a rapid transit. Another case I remember quite well was one where I was serving as senior judge, and it was called the Anawake case. In that case, there was a camp for children, wayward children, many of them of families of middle class, upper class people, wealthy people. And these kids were on drugs largely and bad conduct, and they were subjected to all sorts of misconduct, mostly sexual misconduct. And one lawyer essentially took over the claims of all of these people, and there was more than 100, I guess. And it was just too complex a case to ask any sitting judge to handle, because it would take forever, and it would have been maybe 20 or 30 different cases. And so I was asked to take on those cases, and did. And we took maybe a year or two to deal with all the preliminary motions. Many of the defendants were doctors and psychiatrists and others, and lots of insurance companies involved, lots of plaintiffs, lot at stake. And at the end, I was able to segregate about 10 young men as the plaintiffs against a few of the defendants. And then we were going to try the other cases incrementally as we went along. My hope had been and was that we could get a jury verdict on the first group of 10, and that would probably establish damages and so forth. But it was, in those days, it got a lot of press attention, a lot of television coverage was sort of, it had appeal for sometimes the wrong interest to the public. And we set up a separate courtroom. We built a courtroom for that trial. And it was tried over a period of, I think, 10 weeks. We tried that case. In that case, we, for the first time, I believe, in Fulton County at least, television was permitted to be in the courtroom. And we had the television camera in the very back. And no one knew quite what to expect of that. Great opposition to that. Still great concern about television in courtrooms. But we did some pretty good groundwork. We had some really good cooperation from the television stations around. And we had, I think, 2 cameras, which were, what do you call them? They were corporate cameras, shared by all the stations. Mm-hmm. And outside the courtroom was a room in which there were monitors and so forth. So it was pretty unintrusive. And yet there was coverage each night from the trial. And I don't think anybody even thought about it after we got started, the first day or two. The fear you have is that people will showboat in trials, but I don't think that happens in most cases because you concentrate on the trial, not on that camera. And so that was an important and a very sad case for me because I saw an awful lot of youngsters who had been hurt and some good people as defendants who had gotten into a situation that you'd never been in, so forth. Dr. Petta was the main defendant. He ran it. He was a former probation officer and so forth, and he was convicted both in a criminal sense. He had been in jail, and also in a civil sense he was. So those were two cases that were, I thought, very interesting and required a lot of legal attention.
After what, 11 years you left the bench?
I did.
Why?
Well, I'd just gotten reelected, and I'd been there for 11 years. I realized that I really wasn't thrilled by the work I was doing. I love the law, and I love lawyers, and I love civil cases. But I found out that I didn't like domestic relations work. It just bothers me. And I wasn't as good at it as I ought to be. I found myself getting too uptight to hear people destroying each other. And you know, we have jury cases for divorce work in this state. Not much anymore, but that was big in those days. And I just was brokenhearted with all the criminal work I was doing. In those days, and still to some extent now, people thought, quote, real justice took place when you were harsh. I'll never forget one day, wonderful deputy sheriffs in my courtroom, and that particular day I had a series of sentences I had to impose, all of which compelled me to sentence these folks to the penitentiary, to prison, because they had prior offenses and so forth. And I knew exactly that that would not help this community. They would come out just as bad as they were when they went in. They would cost the community a fortune. Their families would be without support. There was no gain in most of those cases. And I suppose, in total, I just found out that that wasn't the way I wanted to spend the rest of my life. So I resigned. I was gratified by people's appreciation of the work that had been done, but I was more excited about what I thought I could be doing in the world of teaching and so forth. Mm-hmm. So I did.
You went to Emory?
No, I first left and went up to the University of South Carolina, where Ellis McDougall, whom you remember quite well, mm-hmm. Ellis McDougall was helping put together a criminal justice school in the University of South Carolina. This was a school to grant degrees to those people who want to be in the criminal justice field without being lawyers. And he taught me, and I admired Ellis very greatly. I thought he was a fine head of Board of Corrections in Georgia when he was here. And we'd become, so he talked me into coming up there, and I did. And I spent 4 years there, sort of commuting back and forth to Atlanta. And at that time I was chairman for 1.5 of those years of what we call the National Conference of State Trial Judges, which gave me which I had to go all over the country to kind of do the work. So it fit in as a good time, and I loved it. I taught people who were in the criminal justice field, some who wanted to become lawyers, others who wanted to become sheriffs and deputies and good people, police officers, and it was a great experience. And then I went to Harvard for a year because I was interested in trying to find out how we could encourage judges to assist in settling cases. And that was a fine year. I was a visiting scholar there for a year, then came back to Emory to teach.
Mm-hmm. How long did you teach at Emory?
I taught there about 9 years, 10 years, I think. That was a good experience. I enjoyed it. I was associate dean for 5 of those years, which gave me a great opportunity to look at academia in a special kind of way. And that was a good experience too. And then I left because I wanted to go into mediation full time, which I'd been doing part time. And so I did that, and I set up an office in the Southeast called JAMS, Judicial Administration and Mediation Services. And that was a company in California that I had been asked to join, which I did for the sake of opening an office here in Atlanta, and did that for about 6 years and was gratified by that. A lot of success, I thought. We had a good panel of former judges who were mediators, and I hope we did some good by training people and lawyers to accept mediation as a viable and useful alternative to litigation.
It seems that's been a great asset to the judicial system.
Well, it has. I mean, and you can't think of a good judicial system today, or I would put it further, a good lawyer today who doesn't understand the prospects and possibilities of mediation. In early days, you know, that was considered sort of a Mickey Mouse operation. Judges didn't mediate, things like that. Now we know that the judicial system simply cannot handle the litigation that's coming before it.
How does mediation work?
Mediation is essentially consensual. That is, both sides agree to mediate. You don't compel somebody to mediate. And the function of a good mediator is to get parties to the table. And when they get to the table, to help them see several things. One, the risk of litigation, which is sort of the down and dirty dead end of a failed mediation. Okay, you don't want to mediate? We'll go to the courthouse. We'll see you down there about 5 years from now when you get your case tried. And $100,000. And destroyed relationships with everybody. Because most litigation, as you know, is between people who know each other. Clerks and, I mean, business people sue another business. So the function of a mediator is to get parties to sit at the table, usually to tell their story. Why are you mad at me? Why are we litigating? Why did this contract not work? Why, Mr. Surgeon, did you not sew me up properly? And let each side tell that story. And it's absolutely amazing. I mean, absolutely amazing how many cases you resolve when you allow that to happen. Everybody's got a story. Sometimes they've imagined things, and sometimes they've dreamed it up maliciously. But more often than not, they tell it the way they see it. They do. I mean, I might disagree with you. You might be a damn fool, but at least that's what you think. You know what I mean? And if you'll tell me what you think, then I can tell you, well, wait a minute, this is not the way I saw it. I saw you doing something else. So the mediation process, and it is a process, requires the mediator to be, of course, both neutral and strong enough to have the parties understand that they're going off on the wrong track. That's not persuasive. We all have lots of stories about mediations which succeed. You also bring into a mediation other parties. I mean, not other parties, but other people, expert witnesses. And if you have a mediation which requires an expert witness who ultimately is going to be in the trial, then for the first time, the other side will hear that expert and will say, wait a minute, there's something to it. You know what I mean? I've had that happen many times. The expert who might have studied this subject for a long time will sit across and look at the other. This is what I found. This is the way I think it's going to happen. This is what happened. If there's a malfunction of a piece of machinery, they can talk about that. And therefore, you have a basis on which now to settle the case. So the mediator will go between the parties and say, they say, Bob, what do you take to settle this case? And of course, it's always going to be the kabuki dance. People will always negotiate, and you are helping them negotiate. And then they have made a resolution, and it is their settlement, and that's what's very important. It's not a jury's decision. It's not a judge's decision. It's not an arbitrator. It's their decision. And all of the data suggests that mediated settlements will endure.
They're binding.
They're binding. They're binding. They're a contract and they're binding. And a mediated settlement will almost always endure because both parties have made a decision that's in their best interest.
You remember some of your most interesting cases?
Oh, sure. Yeah, sure.
Could you share some of them with us?
Well, they range from real big ones to, you know, the little bitty dog barking cases. And maybe start with that. You know, let me tell you one of the first we had in the Neighborhood Justice Center in Atlanta, which still exists. It's good. Does a wonderful work. I had the privilege in 1977 of founding it. About that, I mean, Jimmy Carter had just been elected president, and the Attorney General's Office of the United States put aside some money to try to develop what we call neighborhood justice centers, and Atlanta was granted some funds to do that, and we put together this center. One of the first cases we had was mediated by a young and very capable woman who graduated, I think, from Smith College or from Wellesley or some school like that. And she's the mediator. And in comes these two couples, or these two families, I think families, who lived in the same house. It was a shotgun house. You know what a shotgun house is? You got a hall in the middle. And in the old days, that was good for circulation and separation. And there were kids living on both sides. And the two families were fighting all the time. They were kicking each other's dogs, throwing rocks, doing all kind of bad things. And here comes this very highly educated young woman, sophisticated white woman. And she sees a world she'd never seen before. And she's got this dispute. Now, they had been taking out peace warrants against each other. You know what a peace warrant is? And then, you know, they'd go get the sheriff to arrest them, and they'd hold them in jail and for a few days, and the judge would hear the case and throw it out, and it was chaos. They worked on that thing a couple of days, and finally they agreed that if either side would stay off the property of the side of the other, they could live in peace. And if they didn't, they could knock the hell out of the other one. This was language they knew, except they didn't use the word hell. And everybody knew that that was the rule, if you violated the line. So the young mediator said to this family, now you go out, I'm going to tell you what you got to do. You got to go out and buy a gallon of white paint. I'm telling you, white paint. And you got to go out and get some paintbrushes. And the two of you are going to decide on a straight line right through that house, across the front yard, up to the sidewalk. And that's what they did. Very solemn agreement, you know. They had them in a very solemn, like they were in a courtroom virtually. That was the law. They made the law in that case. As far as we know, we checked out 90 days after that. It was working. And that's a great one. It's hard to think of the larger ones because they do get very complex, but you know, I remember one that was very, very large, where people who had been running steel mills had been burning the raw stuff in chimneys, and the chimneys would be filled up with this black soot. And the federal rules had just, the pollution rules had just been passed. What year was this? This was in the early 70s maybe. And they were selling this soot to a guy down here in central Georgia who was all this truckload of it. And he would pour a lot of fertilizer in the soot. What is it that makes grass grow green? You remember? Some kind of fertilizer, cheap. And he'd pour it in this soot and sell it to farmers. And it had enough of that stuff in it to make the weeds come out good, and then they'd die off. But it was a fraud. The steel mills, 5 of them, were selling this stuff to him, and he was dumping it down here. They were getting rid of that. he was selling to these poor farmers. And I was asked to mediate a dispute between a little black community that was all around the dump site down somewhere west of or east of Macon, Georgia, somewhere. Forgotten now where it was. And they were represented by good lawyers, this black community of people, good people. But children were getting sick. And there was a real question about why they were getting sick. And it, I think pretty clearly came because of all the chemicals that growing out of that stuff. It would leach out into the creeks around there. Well, they tried and tried and tried to litigate it. It would have taken years and years to litigate. The 5 steel mills were all joined together as co-plaintiffs, as co-defendants. And the community of black folks were represented by very good folks. It could have been a class action, but it wasn't a class action. It was a lawsuit. It would have been tried in a rural county. It would have bankrupted the county, try that case, because it would have taken months and months to try. So we mediated that, and I was asked to mediate it. We went into a courthouse that was not being used in that area, an old courthouse. The 5 presidents of the steel mills were required to be there because we wanted people who could make a decision right then. No surrogates, the 5. And their space was the grand jury room in that courthouse, and the people in the community were in the courthouse, on the courthouse floor. And so we met together, and both sides talked about their views and their positions, and the lawyers were of course taking notes, and community representatives spoke, and the presidents of the mills spoke, and their surrogate spoke. It was a good 2, 3, 4 days of communication back and forth, at which the presidents of steel mills began to recognize these were not just aggrieved people. These were some of these were smart people, fair-minded people who had a problem. They had health problems. The long and short is, after a good while, we finally reached an agreement, and it included a number of things. I've forgotten all of which. One was financial, good many thousands of dollars or more than that, to the community. The other was an establishment of an infirmary, a clinic in that neighborhood, with a full-time nurse who for 6 months, I believe, was going to be available and did examine all the children in that community, give them tests, lung tests, breathing tests, everything they could think of, free, paid for by the steel mills. And a few other things. I've forgotten the details, but there were a few other things about which this community could agree. There were 1 or 2 houses, I recall, which were so affected by it that they were condemned by the county, and the steel mills paid for those houses. They were small little houses, but they paid for them. So we reached a glorious agreement, and the parties were happy. The defendants, the steel mills, came out. They thought ahead. They would have paid for years and years of litigation, plus no matter what the jury would have done. The community felt they were respected, and by the way, the medical clinic had a board of which the chairman was one of the members of the community. So they had some governance over the thing, you see. Well, that was one, and that grew out of a willingness of these people to form some consensus around which they could reach agreement.
That would not have happened at a trial.
No. A trial would have imposed something on it, and it could have been 0 for the community. It could have been mega millions of dollars, you see, for the other side. So this was a good result, I thought.
You mediated a very famous case that involved the beginning of the Georgia lottery.
Yes, sir.
Tell us about that.
Well, that was an interesting case. Zell Miller was the governor, I believe.
Mm-hmm.
I was a senior judge at that time. This was after I'd retired. Mm-hmm. It was promising to be a very difficult situation. which you might have called into play the calling of a special session of the legislature. As I remember, the money had already been appropriated for this, so it was complicated in many ways, and it certainly didn't lend itself to traditional litigation because there were too many legal issues, there were too many political issues. It was just going to be a mess. It would have taken way too long. You know, these things can last for years. So I was asked to do it as a private mediator. I was not acting as a state person, I was private. And I charged on a per diem basis for it. And everyone agreed at the outset that I had judicial authority to do what I needed to do, like calling a witness in and that sort of thing, but that everybody would engage in a mediated settlement, and that the settlement, if we reached it, would become the law. Mm-hmm. So we did that. We had a court reporter there. We had I tried to conduct it as informally as I could under the circumstances, but we still had each side. I tried to run a pretty tight ship there because politics was always endangered us. Mm-hmm. And we did. We reached a settlement. It became the law, and we did it. The
lottery opened.
Lottery opened, and we did it, I think, in maybe a week or 2 weeks. We finished it up.
Well, you've certainly had a wonderful career. If you had all of it to do over again, would you do anything differently?
I suppose we all look back, because none of us are as smart as we think we are. We all look back and say, well, gosh, I shouldn't have done this, or I did do this. But in the long reach, I'm now 83 years old. I've had the great good fortune of having a wonderful wife who's 82. We have 3 children and 7 grandchildren. All of them are doing well. I'm talking real well. Several of them, the grandchildren graduated from college now, and they're on their way. And I still have my youngest is 12 years old, and she's a wonderful child. I've traveled a great deal. In teaching, I taught in South Africa for a year. I've been there several times. I've lived in Europe for a year in Hamburg, Germany. I've been in the military twice. I was in the Korean War when I was a little lieutenant there, and I was in the last 2 months of World War II, I was in the Pacific. So I've had so many good things happen to me that I can't think of anything I would not do that I've done. I'm sure there are a lot of things I should have done that I didn't do. But, you know, with good health and good friends and good luck and a good heritage from my father and mother, I can't, anything I said I'd want to do differently, I'd sound like I'm complaining. And I don't want to complain.
What was your proudest moment?
Well, no moment was more important to me in my life than when my wife said she would marry me.
Well, we all say that.
We all say that. That's gosh, I don't know. So many things have happened to me that are good that I'm very proud of. And probably with no right to be, but I am.
Your biggest disappointment?
My biggest disappointment. Well, in a funny sense, not a funny sense, in a strange sense, I remember when I was 17 years old, like so many people at that age, I would have almost given my life to go into combat. I enlisted at 17, hoping and thinking I could get in before the war was over. And I was in the Pacific for 2 months, but I never saw anything like combat. And that sounds crazy today. It sounds crazy. But I remember almost getting to be frantic not to get in the military and not to be a combat soldier. That's not really sensible, but as I look back in my life, I wish I could have said to myself that I had been a good soldier somewhere, or sailor, or whatever it was.
Finally, how would you like to be remembered?
I'd like to be remembered as a good father, a fellow that was good not only just to his children but for his children, and left them the kind of heritage I think my father left me, which was the memory of someone with integrity and a certain kindness, who had failings and faults like any other human being, but who still nonetheless was a good example for the future for their children. I guess that's how I'd like to be remembered, and one who loved the law and loved being in the law business.
I'm sure, Jack, that you have many more memories. Can you think of any you'd like to share with us before we end our conversation?
Yeah, I can. We all do, and forgive me for going on, but I mentioned that I'd lived in Europe, Hamburg, for a year. When I finished college, I was at Davidson College. This is after World War II. There were masses of people in displaced persons camps who were trying to leave that situation and go to the United States or to Canada, Australia, or somewhere. They were displaced persons from Eastern Europe mostly, Lithuania, Latvia, etc. I was asked to go over there as what they called a displaced persons resettlement officer. I just finished college. And the function was to identify people in displaced persons camps who would be eligible to come to this country because they couldn't return wherever they came from. I had been in the military a brief time. This is before I was called back for the Korean War. And I thought I knew something, but I didn't know anything when I got over there until I met the kind of heroic people that you see who are living in adversity. I saw people in displaced persons camps who had been heroic. They had fought the communist Russians came in after the war, or they'd fought the Nazis during the war. They had endured life that I could never have imagined, and yet were generous and kind and good people. And I suspect a lot of people reached that kind of understanding long before I had, but I had not realized how courageous and brave you could be, and how remarkable you could be, having endured what many of those people had endured. So that's a memory I have that I almost think of every day. Mm-hmm. And I'm grateful for that memory.
Mm-hmm. Jack, on behalf of the Richard Russell Library at the University of Georgia and Young Harris College, I would like to thank you for being our guest.
Well, you're very kind and patient. I appreciate the chance, Bob, to see you again. It's been wonderful. Good. Thank you.